Sorry?
She said who was the other one that lost away? I think they both have to go back.
Chapman
And Shannon.
On the record, in the matter of the people of the state of Michigan versus Dante Robinson. Our file number is 23-03626. Council appearance.
Good morning, Your Honor. Joel Martinez appearing on behalf of the people of the state of Michigan.
Jacob Rowley on behalf of Mr. Robinson.
Okay, today, Mr. Robinson was scheduled for a final pre-trial. And there is a jury trial that's scheduled for December 17th. How are we proceeding on this?
Thank you, Your Honor. I've called the hallway as well as the courtroom for our victim, Robinson Beasley. I did not get a response. I do not believe the victim's present today. I don't see them on Zoom, so people are unable to proceed this time, Judge.
Thanks for move to dismiss.
Oh, what did you say the victim's name was?
Robinson Beasley. I think that's the last name, Judge, is hyphenated.
Okay, I don't see a Robinson Beasley on to that either. A motion to dismiss is granted without prejudice. Mr. Robinson, the matter could be reissued against you if the people reissue it within the statutory time frame. Okay?
Okay.
Okay, and then there was also a, oh, that's not his, this is Mr. Chapman. That's all we have for Mr. Robinson today.
Yes, sir.
Okay, you're all set, Mr. Robinson.
Thank you.
You're welcome. On the record, in the matters of the people of the state of Michigan versus Deontay Chapman, 24-01767 and 24-02009, council appearances.
Joel Martinez appearing on behalf of the people of the state of Michigan.
Jacob Rowley on behalf of Mr. Chapman.
Okay, I have two files. One was set for final pretrial today on a domestic violence, and the other was set for final pretrial on the larceny. Our witnesses on the DV. How are we proceeding?
Thank you, Your Honor. On the larceny file, Aubriana Richardson is the victim. It's my understanding that they're on Zoom and we are able to proceed on that matter. I've spoken with Mr. Rowley. I believe we're just asking the matter be set for jury trial at this time. Regarding the domestic violence file, that's 242009 SM. Victim in that case, Kelsey Hernandez. She's not answered my calls, Judge, in the hallway or the courtroom. I don't believe they're here this morning. The people are unable to proceed on the domestic matter.
Counsel.
Thanks with motion for dismissal of the domestic violence.
Okay, as to the domestic violence, that will be dismissed without prejudice. The people can issue the charge within the statutory time frame if the witness is prepared to proceed, okay? Mr. Chapman?
Yes, ma'am.
Did you, okay. As to your larceny, it's going to continue to trial. The trial date is set for December 17th, 8 o'clock in the morning, in person at the court, okay?
Yes, ma'am. Yes, ma'am.
Do you have any questions at this time?
Do I get my privileges back now since my case is dismissed?
His privileges were put on the DB.
Yes.
Give me the DB file back, please.
My understanding, may I make a record for a moment?
Yes.
Thank you. My understanding is that Mr. Chapman has a felony matter. It's currently pending in service. I believe that is Mr. Pfeiffer's to handle vertically, and it's my understanding that his privileges are revoked in that matter, Judge.
Okay, I do see that I did revoke his privileges in this file. So obviously this file, whatever privileges were associated to that, be removed. But if your privileges were revoked in the felony file, I can't address that for you, okay?
Miss Simmons, my privileges were never revoked for the felony file. It was for this file.
I can't speak to that because I don't know anything about it. I'm just telling you as to this file, your privileges will be restored as it relates to this file because this case is dismissed.
Yes, ma'am.
Okay.
May I address
On the larceny?
on that as well as a pending probation violation which has been set out because it's related to the felony.
He's on probation? I don't have the probation file.
It's not set for anything today. It's been set out indefinitely.
I get it. For me to address it, I need to see what's going on in that file. I don't even know what the violation is.
Well, with regard to the larceny, then the county currently has no bond. So, this requested bond is that. Is $30,000, 10% bond on the bill.
Bond will be amended in this file or set at 2,000 cash surety.
In your honor, if I may make a brief record, understanding the court did just make its ruling, but I just
Yes.
for record purposes. Your honor, this is an
State
individual.
your-
Abigail
yes.
Wilson for the people, I apologize. This is the individual who appeared at court with the victim on the domestic violence matter that was just dismissed. Additionally, the victim on this current matter is the victim in the domestic violence file that he's currently on probation for. I believe this is a violation of that probation, as well as additional felony matters that are currently pending in circuit with the same victim that are also violations of his probation.
Okay. I vaguely remember, did he waive the matter with circuit court? Is that
He
what?
did, that is
Okay.
correct.
Okay, and then I think I was holding the probation violation.
Correct, since they were the basis of new charges.
Well, this one, he originally did have a bond of 2,010%. There's a no contact order that's in place on that. I don't see where he violated this bond in particular. So I would move it to 2,000 cash surety on this file.
Thank you.
Doesn't sound like that's gonna get him out of custody because he has other matters to do, but at least that one will be addressed. Any additional matters for the record today?
From the people, Your Honor, thank you.
No, Your Honor.
You're all set for today, Mr. Chapman.
On the larceny, I have a $2,000 cash surety 10%.
2,000 cash surety. Any other questions, sir?
No,
Okay, you're all set.
my lawyer though.
He's in court right now. He'll schedule a visit with you.
All right, I need you to come see me today, sir.
I'm sorry?
Also addressing my lawyer, I said, asking, can you come see me today?
If I have time. I'd be-
Depends on what time you get out of court. He might be in court all day.
So where did I do it?
Is what he says, okay?
All right, thank you.
You're welcome. You're welcome. On the record in the matter of the state of Michigan versus Cornelius Shannon, 24-02619, council appearance.
Good morning, Joel Martinez, appearing on behalf of the people of the state of Michigan.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Shannon. He appears with us today remotely from the Ingham County Jail.
Okay, I see someone identified as Tiara Richardson. Is that a victim on?
Your Honor,
No, that's somebody else. Okay.
Right.
Okay, you did say, I know you had someone that was a victim. Did I release your victim? I don't see her on here. She already gone.
She's still on.
Oh, Ariana Richardson.
Yes, I'm here.
You're free to go for today, ma'am.
Okay, thank you.
You're welcome. Okay, back on the record on this matter. Mr. Shannon was scheduled for a final pretrial today on a domestic violence. Let's see. Jury trial scheduled for November 5th at 8 a.m. Are we continuing to trial?
Thank you, Your Honor. The alleged victim in that matter is Chauncey Martin. I have called for that individual in the courtroom and the hallway. No answer. I will note for the record, Judge, that my office attempted contact with the victim on September 11 as well as September 19. We were unsuccessful in making contact both times. Given that they're not here this morning, Judge, the people are unable to proceed.
Counsel.
Thank you, Your Honor. Given that, I would motion the court to dismiss the matter against Mr. Shannon today, considering the matter is the dismissal will be without prejudice, of course. And I would also note that the same complaining witness also failed to appear for the preliminary examination when this was originally felony charged. So, thank you.
Case will be dismissed without prejudice. Other people do have the right to reissue the charge against you. Do you have any questions today?
For me,
Yes, you.
so the domestic violence is dismissed with prejudice or without prejudice?
It's dismissed without prejudice.
Okay, thank you. No questions.
Okay. Any additional matters, counsel?
Nothing additional from the people, Your Honor. Thank you.
Nothing additional on behalf of Mr. Shannon, Your Honor. Thank you.
Thank you. You're all set, Mr. Shannon.
Okay, thank you.
You're welcome.
Thank you, Judge.
Thank you. On the record in the matter of the people of the state of Michigan versus Usinel Viltre, 24-02235, counsel appearance.
Good morning, Joel Martinez appearing on behalf of the people of the state of Michigan.
I might have to leave because those are comments.
You can go ahead.
If you need me back, text me.
Jacob Rowley on behalf of Mr. Biltrey.
I have an interpreter via Zoom.
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm to interpret in the matter before the court completely and accurately and not divulge confidential communications to all of you got?
I do, Your Honor.
Thank you. Today was the date and the time set for a pre-trial.
Hoy es el día que se puso para una audiencia
Child abuse court and the domestic violence.
el caso de abuso de niño y violencia doméstica.
How are we proceeding?
¿Cómo vamos a proceder?
Your Honor, I spoke with the victim in this case on Friday.
Hablé con la víctima el viernes.
She is also present this morning in court.
Ella está presente hoy aquí en el juzgado.
Based on my communication with the victim over the telephone on Friday,
Basado en la comunicación el viernes sobre el teléfono,
the people are moving to dismiss this matter without prejudice.
la gente está dispuesta a despedir el caso sin prejuicio.
I would simply ask that the accused be advised that this can be reissued in the future.
Simplemente que se avise al acusado de que esto se va a anular, pero se puede volver a presentar en el futuro.
Case will be dismissed without prejudice.
El caso va a ser despedido sin prejuicio.
However, this matter can be reissued.
Pero este asunto sí se puede volver a presentar.
Do you understand that, sir?
¿Sí lo entiende, señor Viltre?
Yes.
Do you have any questions?
¿Alguna pregunta?
No.
No.
I will get you a copy of your dismissal in just a moment.
Ok, ahorita le van a dar una copia del caso despedido.
Thank you.
Okay, you're all set.
Es todo. Thank you, Your Honor.
Thank you. On the record, in the matter of the people of the state of Michigan versus Robert Hart, 23-00356, counsel appearance.
Good morning, Joel Martinez appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Lawrence, on behalf of Mr. Hart, who is standing to my right.
Okay, I have a final pretrial scheduled today for Mr. Hart. I think that this was supposed to be for a screening for mental health court. Is that accurate?
That was previously what was set out, Your Honor, yes.
Well, that was the last date that I had, offered to definitive complete mental health court and people will dismiss charge. How are we proceeding?
Your Honor, it's my understanding that the defendant was screened and there was some issues about the qualifications for being admitted into mental health court. So I don't believe that was a viable option. That is a viable option at this point. I will indicate that the victim in this case, Kalimba Kasoga, Kasoga, is not present this morning. We've attempted contact on August 26th. We made contact, she indicated she would call us back. And then yesterday, October 21, we made contact again. Victim indicated she wanted the matter dismissed and she has failed to appear this morning, so I am unable to proceed, Judge.
Counsel?
Thank you, Your Honor. Given that statement by Mr. Martinez, I would make a motion for dismissal.
Court will grant your motion. The case will be dismissed today without prejudice. The people do have the right to reissue the charge against you. You understand?
Yes, Your Honor.
Issue a copy of the dismissal in just a moment, okay? Thank you. On the record, in the matter of the people of the state of Michigan versus Tyron, Pixon, 24-02337.
Good morning, Your Honor. Joel Martinez appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Mr. Hickson, who is standing to my right.
Okay, Mr. Hickson has a final pretrial today on one count of domestic violence. How are we proceeding?
Thank you, Your Honor. The alleged victim in this matter is Cersei Emery. For the record, that's C-I-R-C-E, last name E-M-E-R-Y. We've attempted contact with Ms. Emery before the pretrial and also again before the final pretrial. There was no answer either time. We've been unsuccessful in making contact. And that individual is not present this morning, Judge, and the people are unable to proceed.
Given that, Your Honor, I'd make a motion for dismissal.
Motion to dismiss is granted without prejudice. The case can be reissued against you. Do you understand that, sir? Do you have any questions? Okay, we'll get you a copy of your dismissal in just a moment. On the record in the matter of the people of the state of Michigan versus Jakara McLane, 18-1189. Appearance, please.
Good morning, Joel Martinez appearing on behalf of the people of the state of Michigan.
Edgar Barron, on behalf of Mr. McLane, Your Honor.
Good morning, how are you? Okay, today was the date and the time that was scheduled for a final pre-trial on a retail fraud. So there's going to be a no contest plea, is that correct?
Yes, Your Honor.
What is the reason for the no contest?
Lack of memory, Your Honor.
That's accurate, ma'am? Raise your right hand. Do you swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, you don't have a memory of this?
No.
Do you have some kind of health issue that caused a lack of memory?
Yes, ma'am.
Okay. You understand that in order to plead no contest, you would have to understand certain rights and be willing to give those rights up?
Yes, ma'am.
So you read these with your attorney?
Yes.
You understand these rights?
Yes.
You want to give these rights up?
Yes.
Okay, so you have the right to proceed to trial in this, and you could have had a jury trial. You understand that?
Yes, ma'am.
Is there something you need to do?
Oh, no, I was just gonna get that paper out.
Oh, okay, you can get it. No, you can get it out. Okay.
I just read.
Okay, no worries. Okay, so you have the right to the presumption of innocence. That means that you are innocent as you stand here until proven guilty, unless you waive that right to innocence. You understand that?
Yes, ma'am.
You want to do that?
Yes.
You have the right to cross-examine or question any of the witnesses that the prosecutor intended to call against you You have the right to remain silent at trial, not have silence be used against you, or you can waive silence and testify if you'd like. You can subpoena witnesses to have a testimony brought forth on your behalf, or you can also present evidence that you believe show a defense to the charges being brought against you. These are all rights that you would have to give up to plead no contest. You understand that?
Yes,
That's what you want to do?
yes,
Anybody threatening you to do that?
no,
Has there been any promises made in exchange for you entering a guilty plea today?
not one,
Okay, are you on probation or on parole?
neither,
Okay, I understand that by pleading no contest, that it could result in a conviction entered against you that may need to be reported to an employer or put on a future job application.
yes,
It also could result in a conviction that may have impact on travel or immigration status that you may be seeking.
yes,
Okay. As to retail fraud in the third degree, do you plead guilty, not guilty, or no contest?
no contest,
Okay, we have a report here in the Lansing Police Department from a date of incident on or about December 31st, 2017, at approximately 7:09 p.m. at the area of 500 East Edgewood Boulevard, City of Lansing, Ingham County, State of Michigan, which we are aware were known to be target. Let's see, on or about 31st at approximately 7:08 p.m., the asset protection team began surveillance. See, it says person identified, last name McLane, made her way to accessories at approximately 7:11 p.m. McLane can be seen selecting a purse listed in evidence section of this report and putting it around her shoulder. McLane then moved to a point of sale 0160. McLane can be seen removing the purse from her shoulder and concealing it in a Target plastic bag and placing it in her cart. McLane does not scan the item at this time. At approximately 7:13 p.m., McLane then scanned several other items and bags them, also places them in her cart. McLane then places the pants listed in the evidence section of this report to the side of the register, not scanning them at this time. McLane then purchases all scanned items, transaction number ending 2354. While McLane is waiting for payment to process, she can be seen grabbing the pants and placing them inside of the Target plastic bag. McLane then places it in the basket. McLane then passes the rest of the points of sale without rendering payment for the merchandise listed in the evidence section of this report. As McLane begins to exit, I approach her and identify myself as a Target security and direct McLane to the asset protection office. On the way to the office, McLane admits she forgot to pay for the Bullseye's playground merchandise listed in the report. McLane enters the asset protection without issue. The amount of the items are listed as the amount of $78.98, says all items were recovered. Any additional factual basis?
People are satisfied with that factual basis, Your Honor, and may I approach with the plea sheet?
Yes,
Thank you.
That's satisfied factual basis.
Your Honor, just one point of clarification. I believe I heard Ms. McLane indicate that she's pleading to retail fraud third degree. It's pleas actually to attempt retail fraud third degree. I just want to make sure that that's clear.
Okay, yep, that should be clear. I think I see that here from my August 20th note that she was going to try to plead guilty to an attempted retail fraud, but I think there was an issue with the factual basis then. And I see the plea sheet here is for you to plead or no contest to add a count two of attempted retail fraud third degree. And you understood that, ma'am?
yes,
Okay, and just for the record, because I don't know that I read it or stated it, at the time of the alleged incident, Target was open to the public. Or any additional factual basis from you, Mr. Rowley?
No, Your Honor.
Okay, if the court is satisfied with the factual basis, I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. Any objection to immediate sentencing?
No.
No objection from the people, Your Honor.
No problem, ma'am.
None from the defense, Your Honor.
I need her criminal history, please.
Not so much as a pardon ticket since 2016 now.
That's gonna be good for you if that's the truth, like.
Oh, it
you're gonna-
is.
That's very good. You need her file to get that. You can have a seat while we get your criminal history, okay? Off the record on that.
Okay, here or there.
Yeah, it's fine.
Okay.
Dominique Blackman failed to appear.
Yes.
Okay, I thought I seen the bonds person,
He was, he just stepped out, I'll find him.
but, you can just tell him the bond is forfeited.
Oh, it's working. Okay.
Yeah, that's fine. Have it. I have the file anyways. On the record in the matter of the people of the state of Michigan versus Michael Drobny, 24-02257.
He's in the hall, Your Honor. I speak.
I'll move on. On the record in the matter of the people of the state of Michigan versus Tiara Richardson, 24-01372. Council appearance.
Good morning, Joel Martinez appearing on behalf of the people of the state of Michigan.
Okay, Tiara Richardson, you can hear us?
Yes.
Okay, and she's present via Zoom. Today was the date that was set for a pretrial. This is for a child abuse fourth degree. How are we proceeding on this?
Thank you, Your Honor. It's my understanding that at this time, we will be setting the matter for final pretrial.
That's correct, Your Honor, and Assistant Public Defender Lauren Sutter on behalf of Ms. Richardson, that is also my understanding.
Final pretrial, November 12th. November 12th at 8 a.m. in person at the court for final pretrial. And then jury trial, December 17th. Jury trial will be scheduled for December 17th, 8 a.m. in person at the court. Do you have any questions today, Ms. Richardson?
No.
Okay, any additional matters for the record, counsel?
Nothing additional from the people. Thank you.
Nothing further.
You're all set? On the record in the matter of the people of the state of Michigan versus Jibreel Warren, 24-02944, council appearance.
Good morning, Joel Martinez appearing on behalf of the people of the state of Michigan.
Jacob Rowley on behalf of Mr. Warren.
Okay, Mr. Warren is present via Zoom. Can you unmute your device, please?
Yeah. Yeah.
Okay. And remove your hood.
Okay.
And you need to remain stationary so that you don't lose your signal while we're in the middle of the proceeding, okay?
Okay. Let me find the seat really fast.
Thank you. Today's the date and the time that's scheduled for a pre-trial. And this is for domestic violence. How are we proceeding on this?
Thank you, Your Honor. I just note for the record that the offer that's been extended at this time is to plead guilty as charged with a Killebrew agreement to no upfront jail. I will note for the record that the defendant has already availed himself to HIDA and 76948 status previously. Based on my communication with Mr. Raleigh, I believe that we're simply setting the matter for final pretrial and jury trial.
Yes, Your Honor, to be clear, my client has not rejected that offer. He's considering it. He would appreciate it, but he's effectively considering it.
Final pretrial November 12th at 8 a.m. Jury trial December 17th. Final pretrial November 12th, 8 o'clock in the morning, in person at the court. Jury trial scheduled December 17th, 8 a.m. in person at the court. Do you have any questions today?
No, ma'am.
Okay, any additional matters for the record, counsel?
Nothing from the people, Your Honor. Thank you.
Nothing from the defense, Your Honor.
Thank you. You're all set, sir.
Okay, thank you. Have a good day.
Thank you. Same to you. Mr. Parker's here for a show. Okay. On the record in the matter of the people of the state of Michigan versus Michael Drobny, 24-02257, appearance, please.
Good morning, Joel Martinez, appearing on behalf of the people of the state of Michigan.
Jacob Raleigh on behalf of Mr. Drobny.
Okay, Mr. Drobny has a pre-trial scheduled for an assault, battery, attempted police officer, assault, resisting, obstruction, and malicious destruction of personal property. How are we proceeding?
Your Honor, thank you. After discussing the matter with Mr. Raleigh, I believe that we're setting the matter for final pretrial.
Was there an offer other than him being screened for mental health court?
Yes, Your Honor, the offer is to plead guilty to malicious destruction of personal property with restitution. That amount's yet to be determined, but it appears to be approximately $500, and that we would dismiss the other two counts.
Mr. Raleigh.
Mr. Honor, my client is going to consider that offer. We would ask that it remain open until the final.
Final pretrial November 19th at 8 a.m. January 13th at 8 a.m. Final pretrial in person at the court, Mr. Drobny, is going to be November 19th, 8 a.m., okay? And then you need to appear for your jury trial January 13th at 8 a.m. Do you have any questions?
No.
Any additional matters for the record today?
Additional from the people, thank you.
Nothing from the defense, Your Honor. Thank you.
We'll get your notice to appear in just a moment, okay, sir? Thank you. Back on the record in the matter of state of Michigan versus Jakara and McLane. You can make allocution.
Your Honor, my client, as I think she began to say, she has not had any trouble with the law since this date of this incident in December of 2017, nearly 7 years ago now. I think certainly this was really an instance of poor decision making and poor impulse control. Like she had a lot of stressful things going on in her life at the time, but that's not the case. She certainly acknowledges wrongdoing and takes responsibility on it. But she has been on the straight and narrow since then, and I don't believe this is something that can happen again in her life. We ask the court to take that into consideration.
Not to mention I did raise 5 by 9.
You said what?
5 by 9.
You raised 5 divine nines. What does that mean, ma'am?
By 9. I did a good job raising my 5 kids, and I didn't always make the decisions, but I do now.
Oh, so you have 5 children
Yeah,
that you raised
yeah,
that are college educated
that's right.
and do community service?
They have masters in education. Yes, they do.
Okay, so that's to be touted.
Yeah,
Everyone doesn't know what divine 9 means. It's probably better for you to state that you raised 5 college educated individuals committed to community service.
that's right.
Thank you. Okay, I looked at her criminal history. She didn't have anything else other than this. I don't even know how we got here, ma'am. Probably was something that was going on
Yes,
at the time.
it really was.
It's an isolated incident. I hope you stay on this track. I don't see any reason why you wouldn't.
Yes.
Again, no other convictions other than a licensing issue from 2011. Your fine is $50. When can you make payment? I will, know, pay by Friday. You'll be all set. Do you have any questions?
Thank you.
Okay, let's see. Did we let the, bondsman know he was all set?
I went looking for Your Honor, I couldn't find him, I figured if I.
He probably melted.
It's possible.
So, okay, sounds good. I don't know, are you all waiting for particular matters?
Yes.
Seabrook. And, Michael. Barron. Mr. Coates is here.
Okay, Seabrook is
Seabrook should be in
here. Okay,
custody.
got it. Sentencing. Okay, on the record in the matter of the people of the state of Michigan versus Michael Barron, 23-01767, council appearance.
Good morning, Your Honor. Angela Belver on behalf of the people.
Where Your Honor, Dustin for Michael Barron.
For Your Honor, present, I think her screen is not on, is Randy Borman, who is the victim of the underlying matter in this case.
Okay, I
On
do
Zoom.
see,
Oh,
I do see Randy Gorman starting her video now. Let's see. Okay, this was the matter that he pled guilty to the bond violations and the people were dismissed the remaining.
that's correct, Your Honor, and I did verify that a nollie has already actually been done. We did it on the day of the plea.
You can make out. Yes.
Okay, thank you, Your Honor. I guess I want to start with why we are here today specifically, Your Honor. This court, I think, has had the opportunity to review the procedural history of this case. The underlying charges started out as a felony. A felony case. This court heard preliminary examination. It got bound over by a probable cause standard. My client and I were ready to try the case when it was a felony. And there were felony charges. It was remanded to district court as a misdemeanor case. We were ready to try the case when there were misdemeanor charges. And in the interim, my client violated bond, obviously, and he's admitted to that. But I give that history just to illustrate
that I think the proper consideration for this court is not what the underlying charges were, but what the bond violation was. Bond violation, my client, he violated this court's orders. That needs to be taken seriously. We're not disputing them. That said, what he is found to have violated for is, and I'm not justifying it, but just to put it in context, it's a fairly run-of-the-mill disorderly conduct type case. It's the sort of thing under MCL 769.5. If this court were sentencing as a substantive separate crime, there would be a presumption against probation in jail. And the case is presently pending, the underlying charges, the charges relating to the bond violation are pending in 55th District Court. My client's currently on bond with Judge Allen. If there is a conviction in that case, whether by plea or jury verdict, I can pretty much guarantee this court that Judge Allen is going to put my client on probation for that. I'm asking, Your Honor, not to justify violating this court's orders, but and not to say that that's okay, but I'm asking ultimately for a fines and cost sentence for the probation violation. I do know that it's a bond violation. I also want to address one other thing. I know probation has yet to receive my client's substance abuse assessment that he did at Cristo Rey. He has provided me proof that he paid at Cristo Rey. I can show the court if the court needs to see that. We just haven't, for whatever reason, haven't been able to get the assessment from them. So we will provide that to the court as soon as we can get it. But it's not because my client didn't do it. It's just we haven't gotten it from the agency. I'll leave it there. Thank you, Your Honor.
I know that there was the victim from the underlying matter here that she wished to make.
I don't know that she wants to make a statement, Your Honor. I think she just wanted to be present.
Okay.
Ms. Borman, is there anything that you'd like to add?
I suppose. I understand the bond violation wasn't specific to the situation that brought us here. I am concerned when it comes to the violation, the dismissal of court orders. The substance abuse piece doesn't pertain to me, more what brought us here to begin with, and the understanding that we may have the freedom of speech to say the things that we want to say, that there are consequences to some of our speech and our actions, and just having that addressed in conjunction with the legal side of like those consequences. And also I am working to get the PPO information and refiling and having him served, which I have not been able to do as of yet. So I just ask that the no contact order remain in place while I work with the court for the PPO.
Did your client want to make a statement at all?
I would like to make a rebuttal.
A rebuttal?
I would like to make a statement.
No, you're not going to address her. You can address me.
I can
though.
address you.
You're not going to address her or her request either.
I'm not going to.
We're going to address the bond violation, which is what you're here for. Because the underlying matter you're not here for. That's been dismissed.
I do have one question. It's been dismissed. Why is she here?
I have no idea, but she
But she
appeared.
came out, so I'm allowed to say something.
I agree. I'm not going to,
face.
but you ask your attorney why she's here, and your attorney can get that information from the prosecutor's office. I am not addressing that. I asked you, did you want to address while you're here to be sentenced before I impose a sentence?
Okay. On the bond violation, I'm sorry I didn't follow your orders. Definitely didn't realize it would get to be all this, I guess.
What did you think was gonna happen?
Yeah, I guess I didn't think, to be honest with you, especially when the charges got dismissed. I just find this whole situation has been just a roller coaster ride from the beginning. I don't know if you've read it all. This started by somebody not knowing the law that worked for the government came to my house. I regressed it online, and maybe it was lawful or not, but it must have been because it's been dismissed. So for over a year, I've been on bond with this court. A government official came to my house, knocked on my door, and didn't even know the law. The woman that, I'm not trying to address her, but she came from CPS to my house, said it was illegal for my son to have a marijuana card. I told her, ma'am, it is not illegal. You should probably leave my house and go look up the law. If there's still a problem, get back a hold of me. She never did. She kept going. I posted her picture online. That was my only recourse. I called CPS. They told me if I come on their property, they send me a letter, a no trespassing, like I'm a threat. So from the beginning of this, she came to my house unlawful. She's made it on court record. She said she didn't know that was the law. My lawyer didn't know that was the law. I think even one of the judges in this didn't know that was the law. I knew that was the law. I was in the law, in following the law, minding my own business in my house. And since then, we've had this fallout. I've had 2 felonies, 2 misdemeanors. She's tried to file a restraining order on me. I've never even met the woman in person. She was on my camera at my house. I posted a picture of her online and said she was at my house unlawfully. She tried to file a restraining order, was denied. She went to Meridian Township Police, tried to get them to file charges on me, denied. She went to Lansing Police Department, had them call and threaten me over this post, denied, no charges. She then goes to her friend who she works with every day and files charges on me. She works with this prosecutor, their CPS, and this woman, if you look this prosecutor up, she prosecutes cases against children. That's her specialty. But this is a friend thing. Everybody else has to press charges, normally calls the police. I've never seen anybody circumvent 2 police departments and a restraining order and get a prosecutor to can convict me. I'm dead wrong for drinking against your orders. I am dead wrong for that. But this whole fallout from someone that didn't know their job coming to my house has been a nightmare. I was charged with 2 felonies, 2 misdemeanors, and all I did is say she came to my house without knowing the law. She did. And then she.
Is that all you said?
Online, if you go look, that's what I said. And I asked for information on her, and I was hoping other people have had the same problem, because that's the way of the world today. If you have a problem, you go to the internet and you air it there. When I called down to CPS to air there was a problem, instead of them doing something about it, they send me a threatening letter. So everywhere I turned, I've got a threatening letter or a charge out of this. I'm dead wrong for drinking on your bond, but clearly I wasn't dead wrong. The only person dead wrong was her coming to my house in the beginning and not knowing her job. If she had known her job, none of this would be here. I spent $7,000 on an attorney. I've taken countless days off work. I've been to jail, all for her not knowing her job and starting something. I posted online that I wasn't happy with what she did. She came to my house unlawfully and didn't know her job.
Okay, so my understanding is the underlying issue is that she came to your house as a CPS worker?
Unlawfully. She didn't know her own
I'm not
job.
gonna deal, I don't know the details, but this is part of her, she came in execution of her duties as a CPS worker.
She thought she was doing.
Well, I don't
She
want you
later
to,
admitted
I'm
she
not
was
asking
wrong.
you to opine, because this is not a matter that went to trial, correct?
Well, that's right, Your Honor, and I was trying to.
Yeah, it's not gone to trial.
It was dismissed. She admitted on your record she was wrong.
Your Honor,
It was dismissed per plea agreement. Let's be clear.
Sir, my understanding is this was not litigated.
Okay.
Correct, counsel?
That's right, Your Honor.
Thank you. It was not dismissed on any merits. You weren't given, exonerated in this matter. You just made a statement on the record that you just made a comment about one thing, but I have the screenshot of what you put on social media. You were soliciting dirt on her, correct?
Right.
Because you wanted to create a problem because you felt like she was creating a problem for you, correct?
Well, I figure.
I
if
could
there's
use
another-
that dirt.
Tomorrow, if someone posts the same thing and I
I
see
know
that
someone
post,
knows her and has some dirt on her, I can use that dirt. That doesn't seem like, what you said is when there's a problem, the way of the world is we go to social media and air our grievances. This is not you airing grievance. This is you posting her picture so that you can, and asking people particularly, I know someone knows her and has some dirt on her.
Right.
So that you can get the dirt because you wanted to use it. That is not the same as you airing a grievance. That's not the same as you making a post saying this person, I believe this person unlawfully came to my house. That's not the same thing. What you were doing in this looks like you were looking to create a problem. That's what it looks like. I don't know what your intent was. This again was not a matter that was litigated. I just know what the plain language of your text messages indicate, that you were looking to create a problem for her because you felt like she created a problem for you.
we were
The other,
looking to litigate.
the other concern, I didn't ask you, were you looking to litigate? I recognize that you hired an attorney, he made it clear on the record he was prepared to go to trial. It wasn't. For at this point, it's been dismissed per plea agreement, and your attorney could advise you. Plea agreements happen for a number of reasons. Just because the prosecution took the position to dismiss this per plea agreement does not mean that they don't believe that the case has validity. It's not what that means. So you shouldn't assume that and then go proceed in the actions that you were proceeding on because of that. Because you could find yourself having another bad year if you do that. You understand that?
Right.
And that's not what you want. You want to get this behind you, hopefully learn something. I don't know what you and Mr. Cruz talk about in private. It's none of my business, but hopefully there was some counsel in there that advised you that even though you came out on top when it comes to the plea agreement here, you don't want to engage in this kind of behavior. Even if you never get a conviction, look at the year that you had because of it.
You don't want that.
It's not meaningful for you. It's not meaningful for your child. It's definitely not meaningful for your bank account.
It's not been meaningful in anything.
Yeah.
Nothing positive has come.
Absolutely. That's not the way of the world. We don't, as adults and professionals, address our grievances on social media. That's what kids do.
Right.
You're a grown man.
I feel like with that said, when I called down and told them that
I'm not asking you all that. I'm talking about you saying that the way of the world is that's not the way of the world. It's not appropriate. Okay, and this again was not an issue where you were just addressing a grievance from what I'm reading. It was looking like a solicitation for some dirt. Nonetheless, I recognize you had a bad year, and I appreciate you taking responsibility for your actions in the regard of you violating the court's order. You were arraigned in this matter back on June 16th, 2023 by the magistrate Millmore, and you had certain conditions. And not only did you pick up a new charge, which was disorderly conduct or disturbing the peace, but you were impaired, visibly impaired is what the report says, which was in violation of your bond condition not to use, purchase, or possess alcohol or drugs without a valid prescription. And I don't care if your case is pending for 1 year or 3 years. I don't care if you believe there's evidence to sustain your guilt or there is evidence. If that's the conditions that you're met with, then you have to follow those conditions unless your attorney comes to the court and makes a motion, Your Honor, can we have these conditions removed for X, Y, and Z purpose? That didn't happen here. So what we have here is something that demonstrates a blatant disregard for what the law is telling you to do. That doesn't fare well for you. You understand that?
Oh, I understand.
You have a pending matter. I have no interest or intention to put this man on probation for a violation of this bond condition, which he has a pending matter on. I'm even surprised he took a plea to it when he has a pending matter on it, but that's a whole nother issue. You will be getting a fine though. Do you understand that? Good luck to you and whatever you got going on over at the 55th District Court. Your fine in this matter is $500. When will you be paying?
I can pay it by the next week if you don't mind. You want it today? How do you want it?
When are you gonna pay?
I can pay by next week with it. You guys charge use a credit card, so I'm just.
So I'll notice you'll be paid within 7 days.
Yep.
Any additional matters for the record?
I just want to place on the record, Your Honor, that just for the record, this case, the underlying matters was found over, it survived a motion to quash. The dismissals were not on the merits. I chose not to try this case in circuit court on Judge Dragonchuk's docket. And when the case was remanded here, and there was a bond violation, I chose to negotiate a plea on what I knew that Mr. Barron would plead to. Rather than drag Ms. Borman through a jury trial in this courtroom. So the court was right when the court indicated that a plea bargain was negotiated, not as a result of any decision by the people on the merits. I would also indicate for the record that there was no denial of the Meridian Township Police report. Meridian Township investigated it, referred it to the Lansing Police Department because Lansing had jurisdiction. Lansing didn't deny it. They submitted it for charges. It was reviewed by me because it landed in my queue and I reviewed it.
Not because you're friends.
Not because I'm friends.
Borman, who probably just works for Ingham County as well.
I do know Ms. Borman and I do work with her professionally, but sometimes I do review cases that don't have to do with child sexual abuse or child physical abuse, because sometimes we're overwhelmed and my office assigns things to me that aren't related to that.
I recognize it, and I don't think it's fair for the defendant to make allegations that they're friends and that this was moved forward because of that. I don't even know where you got that information from, but the prosecutor works with, the prosecutor's office works with people who work in all of the departments of Ingham County, whether it's child protective services, whether it's the public defender's office. That doesn't mean that they're friends or that they're working in cahoots. That's something that your attorney should have dispelled. So that you would understand coming in here that just because they both work in Ingham County doesn't mean that they're friends. You understand that?
Yeah.
I don't know. I don't know anything about their personal relationship, but I'm just saying that we can't assume that just because they work for Ingham County, that they're friends, and that this was prosecuted because she picked up the case because she's friends with the alleged victim in the underlying matter. That's not how cases are issued.
Well, I hope in this whole thing of everybody.
And for the record, this prosecutor can't just decide I'm gonna go take a case. I don't know if you knew that.
Okay. I've seen prosecutors with no evidence at all
I
filed.
recognize that.
Wrong
You have a lengthy criminal history, so I'm sure you've seen a lot.
Right. But I've seen you
But
run
I'm
into-
explaining to you how it works in Ingham County,
Right.
okay?
Right.
All right.
I've been through Ingham County.
Okay, I'm sure. You pay your fines within within $500 within the next 7 days.
We could solve all this if they would stop.
No, excuse me?
If she would have never.
Do you
came-
want a contempt while we're here? Because we can make it happen.
All right. All right.
And that one won't be with the fine.
All right.
You understand?
Yes, sir.
Okay. Learn to control your mouth when you're in court. You have an attorney to speak for you. Let him do it. You paid him $7,000. Let him do it. Okay?
All right.
Have a good day.
Yeah.
Seabrook. On the record in the matter of the people of the state of Michigan versus Kerry Alonzo Seabrook. I have 24-01395 and 24-01707. Council appearance, please.
Abigail Wilson from the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of file number 24-1707, please.
Hey, good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearing on behalf of the misdemeanor files. I will defer to Mr. Feigelson regarding allocation of the hearing today. Thank you.
Oh, okay. Should be a probation file on the case.
Or the misdemeanor using.
Yeah, that's why. Did you call it? No, okay.
This is
All right, look, sir.
Thank you.
Excuse me? Oh, I'm sorry. Oh, I was nervous.
It's fine, Judge.
No, she gave me a wonderful.
I think my client waved to his mom and Miss.
I thought
Wilson-
she was the victim and I got a little heated. Apparently she's
Oh,
mom.
okay, got it.
I'm happy to look that young. We can. go with
Okay,
that.
you're Mr. Seabrook's mother.
Yes, ma'am.
Okay. Sounds good. Okay, I have the files here. Seven oh seven. So that one was. Okay, and Ms. Sutter was deferring to you on the allocation. Is that correct?
That's correct, Your Honor.
That's correct, Your Honor. It's all in one together, so rather than splitting attorneys, Mr. Ferguson.
That sounds good.
Judge, there's one thing I think me and Miss Wilson need to
Can you
address.
speak up a little higher for me?
Yes, Your Honor, there's one thing me and Miss Wilson need to address with the court about the plea agreement. Your Honor. I'll defer to Miss Wilson.
So this one that he was supposed to plead guilty to amended count one of use of controlled substance.
Yes, Your Honor. So as part of that plea agreement, there were a number of files that were wrapped up as part of a global. Prior to Ms. Sutter coming on to the domestic violence case, John Lee was on the file and I had negotiated with him regarding some of the PA 53 violations. And one of those negotiations was that the people would not pursue any GPS interference charges. After Ms. Sutter took over
you said was to what?
To not pursue any GPS or electronic monitoring device interference charges.
Okay.
After Ms. Sutter took over the case, there were additional PA 53 violations that we started negotiating on with as well. And I kind of forgot about the GPS interference plea that I had offered. And so it wasn't a part of the original plea agreement that we placed on the record. So I just wanted to make it sort of updated to include that. So Mr. Seabrook gets the benefit of that bargain, as I believe he understood that he was getting it. I did type out a stipulated updated plea agreement and send it to councils. We have all signed. It's my understanding Mr. Seabrook is okay with this update. As I suspected he would be, it is to his benefit. But since he is incarcerated, we didn't get his signature. So I just think that we need to acknowledge that that is part of the plea agreement and it's not prejudicial to the defendant and we are prepared to move forward with that to say.
Mr. Seabrook, you heard everything that was stated by the prosecutor?
Yes, ma'am.
And you are in agreement with that, sir?
Ma'am.
Okay, and I think that since the last time I saw him on these files, he did submit a letter to the court. I don't know if counsel got a copy of that letter.
I have not. Thank you, Your Honor.
Your letter was read by all parties. It's been placed back in the file. Do we need to make corrections, updates, or deletions to the pre-sentence report at all?
Not for the people.
Nothing on behalf of Mr. Seabrook, Your Honor.
Make allocution.
Thank you, Your Honor. One, court, as the court's aware, his mother is here today, Your Honor. I had a conversation with Mr. Seabrook over Zoom this morning about the sentence with regards to the use of methamphetamine. I know the court is recommending probation. Mr. Seabrook is on board with that. I think he wrote a letter to the court indicating he's gonna do everything in his power to work through probation and get through it. I do know he's got appointments set up with CMH. I conferred that with his mother this morning. I do want the court also to be aware he had a traumatic brain injury when about 10 or 15 years ago, and that has impacted some of his ability to get through things, but he is willing to work through with CMH to help get not only through that, but his addiction to substance abuse. I believe he's gonna get through probation. I did discuss with him, based on everything else, that what could happen if he violated probation, and he is willing to do the terms necessary on probation. I'd ask that the recommendation be adopted in that file, and I would ask that he be given credit for the time that he served on the domestic violence case today, Your Honor. Thank you.
And the victim is not present, correct?
That's correct.
Did your client want to make a statement at all, Mr. Ferguson?
Mr. Seabrook, do you wish to address the court?
I know that I've made mistakes and I am willing to do what I need to do to prove to the court that I am I have improved and bettered myself. I hope that I will not be seeing you again in court, and this will be my last time seeing you guys.
I hope that is the last time I have to see you in this capacity. I don't say it's the last time seeing you, because Lansing is small, or we do weddings here. It could be a number of things. You might have to come here, take care of other business in the court. So that's not my concern. My concern, sir, is you cycling through the system and being before me on 10 plus cases at a time. That's my concern. I was going to note, since you've been in custody, the transformation is in your body is evident, because this is the best that I've ever seen you look. So your body is taking advantage of this time that you've not been able to expose yourself to the poison that you were exposing yourself to. And so hopefully you see that in yourself. Hopefully your mother sees that. And you utilize this new opportunity that you're going to have, because I am going to put you on a term of probation, to get some help, get some tools that'll help you sustain some sobriety and some clean living, and then be true to your word that we won't see you in this capacity in the future. It's not necessary, sir. So with that being said, I think I don't know why I'm getting feedback from the jail today. But with that being said, I'm going to adopt the report. I will place you on a term of probation. And so the term is for 12 months probation. While on probation, you're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. You're not to use or possess alcohol, marijuana, or controlled substance without a valid prescription. Do you understand that?
Yes, ma'am.
You will be required to submit to random preliminary breath testing while on probation and urinalysis testing, and you have to pay the cost of that, okay?
Yes, ma'am.
You're not to engage in any assaultive or threatening behavior. You're not to be at any bars or any nightclubs. You are required to maintain employment and provide evidence of that, okay? What kind of services does Seabrook Superior Services provide?
I'm a handyman, Your Honor. I do work for siding, roofing, landscaping, and pretty much any work that I can find available. I'm a handyman. I fix things.
Okay. So I'm noting that you indicated you were employed full-time, self-employed with Seabrook Superior Services. You'll have to provide evidence of that employment, okay? You are going to be required to participate in some services, including outpatient substance abuse. And I'm going to order that you complete the domestic violence program, okay? you have any questions about your conditions of probation?
No, Your Honor.
While on probation, there's a $30 per month oversight fee that you are responsible for.
Yes, ma'am.
Okay, and so for 12 months, that's about $360 for a year. There's a $75 crime victim rights fee that will be assessed, plus a $50 state minimum cost that will be assessed. I am going to waive discretionary fines and costs. I don't see any cost recovery in here. So none will be assessed. Total fines and costs is going to be $485. You will be making monthly payments on that, so that's about $40.41 a month, okay?
Yeah, thank you, Your Honor.
That does not include the cost it will, that is attached to your PBTs and your analysis testing, okay?
I understand.
Okay, there's an advice of rights as to probation. States you've been placed on a term of probation before the 54A District Court, and your terms are specifically tailored to address your assessed risks and needs. You do have the right to request early discharge from probation on this file once you've completed half the original term ordered by the court, so long as you've not violated any of the conditions within the 3 months preceding your request, and you must have completed all of the ordered programming. You understand that? Okay, so 6 months in, if you've completed outpatient or you've been in outpatient doing well, and you have also completed your domestic violence and you've been compliant with no issues, you can make a request by using the court's MC 512 form that's on the court website, or you can request it from your probation officer. You would complete that form, file a copy of it on the probation department, and then you must serve a copy of it on the prosecutor's office. The prosecutors have 14 days to respond in writing with any objections to your early discharge. If I set it for hearing to address your request for early discharge, you have the right to be represented by an attorney, but you must hire an attorney. You do not have the right to court-appointed counsel for a hearing for early discharge. I've never held a hearing for early discharge, but it could happen. Do you have any questions about that?
No, Your Honor.
As to the domestic violence, the credit time served on that file. Where's your home address going to be, sir?
6487 Green Road.
Okay. And your phone number?
517-974-5426.
Okay, you're gonna be released from custody because I believe he's only being held on these, or is it
I
something?
believe that's my understanding is, he's completed his P53 violation sentence, so the only thing holding him is the bond on these files.
I had him for something yesterday. What was it, a show cause?
It was a show cause, Your Honor, yes.
Okay, and then. Okay, I need you to come in and check in with probation within 48 hours of your being released from custody so that they make sure the information they have for you is accurate. You're gonna have to review the judgment of sentence and sign it, okay, sir?
Yes, ma'am.
Do you have any questions?
No, Your Honor.
Additional matters for the record?
Just, go ahead.
Your Honor, probation did recommend a continuing no contact with Kelly Hooks. The people are also requesting that.
I was wondering why that was on this file, actually.
She is the complaining witness on the domestic violence file.
I can't continue a no contact order if I credit him time served. However, because I'm not putting him on probation on that.
Right.
So, but I was wondering that was what stumped me. I'm looking at the recommendation on the felony and it had that on there, and that's what I said, this must be on the wrong file. So they would like it, the no contact order. I could continue it on the felony file.
That would be our recommend or our request, Your Honor.
The question I have, judges, can we do that? Because if there was never a no contact order on that underlying file, can there no contact?
I don't see where there was no, I don't think that was ever ordered in the,
On the felony file, there wasn't. I don't know that the court can impose it as a term of probation. A lot of terms of probation are not an original
Yeah, I
term of
don't-
bond.
it was not, yeah, I don't have that there was a no contact order on the original case, but that again doesn't mean that he can't have a no contact order as part of his,
Judge, I had one other thing I wanted to address.
I mean, it's part of his probation, so I will continue, or I will impose, I should say, not continue, no contact with Kelly Hooks.
Thank you, Your Honor.
Judge, I had one thing I had a conversation just a moment ago with my client's mother, and I think that the court ordered part of his probation.
He reported that he was employed full-time when he was met with probation.
Just want to set him up for something for failure. Full-time becomes an issue because of his
He reported full-time employment when he was interviewed, so that's what it says. I asked, was there any changes? I was told there were no changes. So it says he works full-time for Seabrook. I just told him he needs to provide evidence of that.
Good enough for me, Your Honor.
Works for me.
Thank you.
Nothing further.
Thank you. Any additional matters?
No, Your Honor.
No,
Thank
Your
you.
Honor.
Nothing further.
You're all set, Mr. Seabrook.
Thank you, Your Honor.
Does it give me a credit or account, I should say? No. For how many days he served on this DD file?
I believe it was 173. I mentioned in the probation file on the substance use.
Okay,
So he would have gotten the full 93 days on the domestic.
thank you. So that resolves that. Really gotta figure out this feedback from the jail, because it's just not necessary. Okay, and Mr. Clark is here for a show cause, is that what's happening? Mr. Clark?
Yeah.
Okay, this is the people of the state of Michigan versus Darren Clark. I have 22-01007. You were scheduled for show cause today, and let's see. Because you owe some money to this court. Looks like you owe $870. What are you being held on? Excuse me?
Cause yeah, I didn't hear you, what you say?
What are you in custody for?
Probation violation and, I guess, not get a sense here in Mason County. With that whole collaboration, deal I had with Sarah Denney.
Sarah Donnelly
Yes, ma'am.
on that one? Was it for probation? Is it in appear for something or something? Or for violation? Okay, reset this until then so I can know what's gonna happen. Okay, I'm gonna reset your show cause because in order for you to tell me when you're gonna be able to pay, I need to know when you're likely to get out of custody, okay?
Yes, ma'am.
You're all set for today.
Can I ask you a question, ma'am?
You may.
I thought this is for my probation violation. Will my PO or my attorney come see me here to get situated about that?
This was for a show cause. This was not about your probation violation. Was he arraigned on the probation violation?
Well, I think he was when he was picked up.
He
and then
requested
set
an
it
attorney?
for a hearing.
Okay, so you look like you were arraigned recently for the probation violation. Is that accurate?
I was arraigned
On the
for
14th?
I was arraigned on both of the violations. I mean, both of my ones, I guess, for 1 year Mason and 1 in Lansing.
And you requested an attorney for the probation violation?
They gave me the attorney. I thought Ms. Dunn was my attorney and, Randy and whatever, I got my probation officer.
Okay, but that's not how the probation, let me just stop you. That's not how probation violations work. Probation violations, if you request an attorney, the attorney assigned to my courtroom will likely be the one assisting you. So we'll find out who's supposed to be assisting you and they can schedule to meet with you, okay?
Yes, ma'am.
Okay, thank you.
What's the name, Your Honor, so I can?
Darren Clark.
Thank you. He's on the, and I missed it, because I was talking to him, this is for a show cause he talked about a separate probation.
Correct. He was here for a short cause today, but he does have, and it's in that file number. Can you tell her what the case that he was remanded on for?
Thank you, Your Honor.
No, the case number that they said he was remanded on in the note from the magistrate.
2-3.
Mr. Abbott is here for, what, we have a trial for the show today? He's at 9. On the record in the matter of the people of the state of Michigan versus Kevin Anderson Millette, 20-01427. Appearance, please.
Good morning, Joel Martinez appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. This is John Abbott representing Mr. Anderson Mallett. He's standing to my right.
Today was a day set for final pretrial. How are we proceeding on this?
Thank you, Your Honor. I have spoken with Mr. Abbott. It's my understanding at this time that the defendant's requesting the matter be set for a final pretrial and jury trial.
Well, today's the final pretrial.
I'm sorry.
We said it later because he had to drop his children off.
Sorry, Judge. Yeah, time got me confused there. I
No worries.
apologize. So what I would request, Judge, is that the matter be set for jury trial. I'd just like to indicate for the record.
It's already set, scheduled for jury trial next week, 29th.
Well, that makes it simple. I just wanted to place the offer on the record, if I may.
Yes.
Extended to Mr. Anderson Mallett, judges, to plead guilty to count 4. And that we would dismiss counts 2 and 3.
You understand the offer?
Yeah.
Okay, let's for you to plead guilty to count 4. You said you'll dismiss counts 2 and 3.
Yes, because I believe count 1 originally started as a felony and that's been dismissed.
That's correct.
Yes.
So that's intentional dissemination of sexually explicit visual material. And so that, or this, I should say, the offer will expire this week, Friday. That the offer would have expired at the time of the final pretrial, but I don't know if that was previously offered.
It was offered yesterday.
Yeah, okay, so.
Might have been offered
Okay.
earlier, Your Honor.
We have to notify our administration by Friday. At what time? Just fine. You have to notify them by Friday if we're continuing, if we're having a trial. So you have until Friday at 9 a.m. to notify us if you intend to accept the plea offer. Okay, counsel?
Thank you, Your Honor. I'll stay in communication with Mr. Martinez and his change. I'll let him know as soon as I know.
Okay, sounds good. Any additional matters for the record?
Nothing additional from the people.
Nothing from the defense, Your Honor. Thank you.
We'll see you in person next week, the 29th at 8 a.m., okay? Is John Underwood here?
Yes, he's in the hallway. In the wheelchair.
Ali, yeah, they just put him on, or is he downstairs?
He's downstairs.
Okay. On the record in the matter of the people of the state of Michigan versus John Underwood, 22-00786. Appearance, please.
Yes, Your Honor, good morning. Assistant Public Defender Stephen Feigelson, stating in from this down on behalf of John Underwood. To council table as we speak.
Okay, today was the date that was scheduled for sentencing. And I did not refer to probation, correct?
That's correct, Your Honor. A victim impact statement, I think.
Okay,
I put this down when we came to this morning.
I don't know that I received a victim impact statement. There's not one on the file. And the victim is not present today.
I believe that's correct.
You can make allocation.
Yes, Your Honor, I know Mr. Underwood has served a few days in jail. I'd ask for that credit. The time this is an older case, he is unfortunately on a wheelchair, and I'd ask for funds on custody of him. Thank you.
Okay, this is a matter from 2022, at least the file numbers in 2022, I think the date of the incident. Actually proceed, well, it's in 2022 as well. We'll credit them time served. It's all set.
I think you're all set. Just need paperwork, Judge, or it's all set?
I don't have anything.
Been nothing up to us.
On the record. The matter of the people of the state of Michigan versus Terry El-Amin, 19-00297, council appearance.
Good morning, Joel Martinez on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. El-Amin, who joins us via Zoom today.
Okay, today was the date that was scheduled for a pre-trial. I have an operating while intoxicated and a driving while license is suspended. How are we proceeding on this?
Governor, may I just have a moment to confer with counsel?
No problem.
Yes.
I'm sorry? A PSI? Well, why wasn't it? Why?
It was put in trays and I had already done the files and I forgot to put it in the
Where is it?
It's right here.
Why didn't you hand it to me? Well, why didn't you hand it to me when you saw it?
I just want to.
Oh.
I'm curious.
I don't remember referring him to probation. He was represented by Coombs. Oh, that's the guy I already sentenced. I'm thinking you're talking about this guy right now.
Oh.
Yeah,
Thank you. I appreciate the court's indulgence there, Judge. Thank you.
no problem.
I was able to confer with counsel, and what we're requesting at this time is the following. It's 2-count complaint here. Count 1 is OWI and count 2 is driving while license suspended. Based on the facts of the case, Your Honor, I believe count 1 should have been charged differently. I don't believe it should have been charged with WI. So what I'm going to do at this point is move to dismiss count 1. I'm going to ask that count 2 remain, and that it be set out 30 to 45 days if the court will allow that. And I believe Mr. El-Amin will be working on getting working through the Secretary of State to get a driver's license, Judge. And once he's able to provide proof of that, that should resolve the matter.
That's also my understanding, Your Honor.
December 10th at 10 a.m. Have any questions, Mr. El-Amin?
That was December 10th,
At
2 a.m.
10 a.m., 10 a.m.
Give me 1 second.
We won't be open at 2 a.m.
You already won't see me here, Your Honor. Sorry.
December 10th, 10 a.m.
Correct.
Okay.
Do you have any questions?
Actually, I do. I was wondering, like, within that time, if there's any delays with that, not up on me, but due to the fact that I have a situation.
If you're having any issues completing in that time frame, get a hold of me, Mr. El-Amin, because then I can
Got you.
communicate with the
Thank you,
prosecutor.
ma'am. Agreed.
You're welcome.
Thank you, Your Honor.
No problem. You're all set.
Thank you.
Okay, let's see. I see Latoya McGee. Can you start your video? And then someone's on a Samsung, but your name is not listed. What's your name? You're muted.
My name on there?
Your name is on there. I'm talking about the person in the vehicle. What's your name, sir?
Edgar Coulter.
Who's representing?
That's my client. I wasn't aware he's online. May I be able to government?
Yes.
Thank you.
And then Bernard Greer is present as well.
My understanding, Your Honor, is that he does not have a public defender.
Mr. Greer?
That's correct.
Mr. Greer, please start your video. Mr. Greer, can you hear me? Okay, well, Mr. Greer is not responsive. Record of the city, I'm sorry, this is, City of Lansing. Today versus Latoya McGee, TU 220150556. Ms. McGee, this is a show cause hearing because you owe $143 for parking in a handicap spot. When are you gonna pay?
I had, my dad was in the car with a handicap sticker, and that should have been taken care of over 2 years ago, but it just keep coming back up. All she said was show her cause of proof of the handicap sticker, and that was 2 years ago. And it said,
who said show you proof of the handicap sticker, ma'am?
whoever worked up at the courthouse. I don't even live in Lansing, so I don't know. Whoever was at the courthouse.
There you go.
So they
Okay,
told me show proof.
So you appeared in court on this matter, is what you're saying, and then you were driving your father, is that what you're saying?
Yeah.
You were driving him to City Hall for something?
No, he was in the car with me.
Okay, why were you at City Hall?
I can't remember. That was over 2 years ago.
Okay, well, who did you show your ticket or your handicap sticker to?
I had emailed it, but I don't even have that email because that email has been locked. But I had emailed it to some lady that worked at the courthouse, and she had told me show proof. I showed proof, and it was supposed to have been thrown out. Last year, I didn't. It popped up again. I think no, it did not pop up, or it did. I can't remember what happened, but it's been over 2 years, and this study popping up, and it was supposed to be taken care of, and I'm not understanding.
What does this mean? Defendant canceled IH and PR. What does that mean? That's a note from the magistrate. Oh, okay. So it looks like you had a informal hearing that was scheduled before the magistrate back in November 2023. And you canceled it, it says.
Probably because I didn't have no way to Lansing. I don't know how it went.
Well, the magistrate noted that you pled responsible to the ticket.
It should have been thrown out. They told me to show them proof, and I don't know how I'll keep coming back up, but whatever.
Yeah, I don't know what your recollection, but that's not what the court record is. The court record is that you were scheduled for a hearing, that you canceled it, and you took responsibility for the ticket. So you owe $143.
Nah, I paid installments.
When are you gonna make a payment?
In 2 weeks,
How much?
$20.
You said $20?
Yes.
Okay. I'll note here that you'll make a payment of $20 within 2 weeks, and you'll pay $20 every 2 weeks until paid in full.
Yes.
Okay, you're all set.
Thank you. Have a nice one.
Same to you. Why? They should have got it in on time. That's just. The prosecutor that needs to meet with Mr. Greer because he doesn't have an attorney unless he wants to waive his attorney. Sir, what's your name again?
Brown. Can I speak to you, Your Honor?
You should probably wait for your attorney.
Sorry, Judge, I was speaking to a pro per defendant. I apologize.
No, you're fine. I think Mr. Greer is proper too, but I'm gonna see if he wants time to get in. Mr. Greer?
Yes, Your Honor.
Okay, on the record in the matter of the people of the state of Michigan versus Bernard Greer, 24-02997, counsel appearance.
Good morning, Joel Martinez, appearing on behalf of the people of the state of Michigan.
Okay, and Mr. Greer is present via Zoom. Mr. Greer, my understanding was that you did request representation from the Office of the Public Defender, but that you were denied, likely due to lack of indigency. Did you want to reset this matter so that you can have time to either appeal the denial and submit further information for your consideration, or hire a private attorney?
Hire a private attorney, Your Honor.
Okay. Have you already made discussions with one that you think you might hire?
I have a friend, he's a lawyer. I need to talk to him. He's busy.
Okay.
I'm not able to.
I'm gonna note that you're gonna hire a private attorney, so I will reset this to give you time to do that, okay?
I do have a job. I work for Amazon, and I wasn't able to pay my phone bill because I broke my finger and I'm on medical leave right now. And I'm in a sticky situation, Your Honor. I live with a racist. I'm in a group home, and he's a racist. He likes saying the N-word, and they keep having conversations with him to stop saying it. I take the bus to work, I take 2 buses. It takes 1 hour and 20 minutes on the bus ride. After the bus ride, I have to walk 35 minutes to work. Mind you, it's at night because I have to clock in at 12:20 a.m. And I have to leave early. I take the 8:15 bus to downtown, and then I wait near the DoubleTree on North and Grand for the last bus 3. And then it takes, like I said before, it takes 1 hour and 20 minutes. After that, I would have to walk 35 minutes to work.
Okay.
By the time I get to work, it would usually be like probably 10:30. I have no rides home. No one does not want to help me. I do have some people that does help me, but they can't constantly do it.
Okay, I understand that you're experiencing some challenges, but I'm not understanding what your issue is as it relates to the court or how the court can provide you assistance.
Yeah, I know. I was just letting you the information, and like I don't know how to do all of that.
Okay, so you're working, you said at 12 p.m. or 12 in the morning?
In the morning, ma'am.
Okay, and you get to work at 10:30 is what you're saying?
Yes, I usually get to work at around 10:30.
So you're getting there early?
Yes, ma'am. And
Okay.
they don't let me in the building because they said that it's part of the rules. They said that I'm not allowed to hang out in the building until I'm able to clock out. So I would have to sit outside on the bench.
But are you on leave right now, medical leave right now?
Yes,
So
but
you're
you're
not working right now?
No, I am about to. My finger is almost at 100%. I'm able to work tonight.
Okay, well, if you've been on leave since the last time you submitted your paperwork for a public defender, that may have changed your financial situation, meaning you could appeal the denial, provide that updated information and maybe get approved, but that's up to you, okay?
Yes, ma'am.
Okay, and then I am sorry to hear that you have these challenges as it relates to your employment and even in your home situation. However, those are not things that are before the court, so I can't do anything to address how you get to work, or I can't make Amazon let you in. It's unfortunate that they would make you stand outside in the dark and not maybe let you go to maybe a break room or something, but I can't address that either. I can only address what you're before the court on, and that is the breaking and entering illegal entry and your request that you have currently been denied on for an attorney to represent you at the expense of the public. And so it's up to you if you want to resubmit that information and provide additional verifications. If you want to do that, I can get you some information today as to how you do that. Is that something you think you want to do?
On how to get a lawyer that's not expensive? Yes.
Okay, well, why don't you try file an appeal of the denial and provide information that you have been on leave to the public defender's office. What information should he contact, or whose information should he contact?
I should call our main line and ask to speak to our office administrator. That's probably the fastest way to do it.
What's the number for the main?
517-679-2979.
Call this number, sir, and ask to speak to the administrator.
Can I get 1 second so I can get a pen and paper?
Yes.
What's the number?
517.
517.
679.
679.
2979.
2979.
And
Okay,
I would ask to speak to Jackie about appealing a denial.
Can you spell her name, please?
Jackie.
Okay. I wrote it down.
Okay, very good. And then lastly, sir, as to your concerns that you expressed with the court that are currently, of course, not before the court. You say you live in a group home?
Yes, ma'am. It's a CMH house.
Okay, if you're having some issues there, you should file a complaint with CMH, and then your complaint also can be filed with the Department of Civil Rights, okay?
Okay.
Okay, and you should Google contact for that and make your complaint that way. Hopefully that helps you, and good luck to you. We'll see you at your next court date. Let me reset this.
Ma'am, when is my next court date?
I'm gonna give it to you right now.
Okay.
Give me whatever the next bill is. November 5th at 10:30.
November 5th, 10:30. Is there anything else, ma'am, that I need to be aware of so I won't miss anything?
That's all you have coming right now is the November 5th date, and you should call or contact the public defender's office about appealing the denial as soon as possible, okay?
So what am I supposed to do, ma'am?
That number for Jackie that you were given, you're gonna
Okay.
call her when you get off the court. You're gonna let her know that you want to appeal the denial because after your arraignment, you were on medical leave, and so that affected your finances.
Okay.
Okay, and then they'll ask for whatever information they need so that they can resubmit your application for a public defender.
I wouldn't be able to pay for it. I can't afford anything right now.
So the public defender's office doesn't charge people. You just need to call and talk to Jackie.
Okay, I will. I'll call her right after this.
Okay, you're all set for today, sir.
Yes, ma'am. Have a good day.
Same to you. Okay, and we're ready for.
I have Mr. Brown, who's here and ready. And I believe Mr. Bowser is in the back, that he's unrepresented, is my understanding.
But we're ready on that one as well.
And then Colton.
Yes, Your Honor, we're also ready on Mr. Colton.
On the record in the matter of the people of the state of Michigan versus Jimmy Brown, 24-01717, council appearance.
Good morning, Joel Martinez appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Mr. Brown, who is standing to my right.
Okay, Mr. Brown had a dog NDOP. Well, there were no attorneys. He did want to make a statement. I had him hold off until his attorney was here. So I don't know if he wants to run that by you before he says whatever he needs to say.
Your Honor, I believe this is a dog license vaccination, not a MDOP.
Oh, I must have the wrong file. This is Mr. Brown. I do have the wrong file. Dog license vaccination. Okay. And he was supposed to have an appointment to get the vaccination done. But he did want to make a statement. I don't know what it was.
I'm not sure what it is either, Your Honor. I would advise him not to make a statement at this point because there is a resolution that's happening today, and I have to address that first.
Okay.
Thank you, Judge. The resolution is that I have been provided proof of license, and therefore I am moving to dismiss these tickets at this time.
Motion to dismiss is granted.
Thank you.
The additional matters for the record.
Nothing further, Your Honor. He just wanted to tell the court he'd gotten it taken care of, which we know.
There you go. You're all set.
Thank you.
Is your shirt says best dad ever? I know there's some people that probably would dispute you.
I doubt it.
Oh, okay. You show them.
I came a long way.
I'm not mad at you. Show them. All right.
That's actually what I've been doing.
Good luck to you.
Have a blessed day.
Thank you. Okay, on the record in the matter of the people of the state of Michigan versus Edgar Colton, 24-03013, council appearance.
Morning, Joel Martinez appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Mr. Colton, who joins us via Zoom.
Okay, Mr. Coulter had a domestic violence scheduled for pretrial. How are we proceeding on this?
Your Honor, discussed with counsel. I believe that at this time we're simply requesting the matter be set for final pretrial. May I place the offer on the record?
Yes.
Thank you, Your Honor. The offer that has been extended to Mr. Coulter is to plead guilty to count 1 as charged with 7694A.
Yes, Your Honor, that's also my understanding and my request.
19 at 8 a.m. for the final pretrial. January 13th at 8 a.m. for the jury trial.
November 19th, 8 a.m. in person at the court is the date scheduled for final pretrial, and jury trial will be January 13th, 8 a.m. in person at the court. Can't believe we're scheduling to January.
It's a little depressing, Your Honor.
Do you have any questions, sir?
No, ma'am.
Okay, well, we'll see you November 19th.
All right. Have a good day.
Same to you. Let's see, who do we have in the back again?
We have Mr. Bowser.
Oh, okay, on the record in the matters of the people of the state of Michigan versus Michael Bowser, 24-02576 and 77, appearance counsel.
Good morning, Joel Martinez, appearing on behalf of the people of the state of Michigan.
Okay, and that was the file that I had, and I should have had Mr. Brown's. It was for dog MDOP and a unlicensed dog, and Mr. Bowser is in court today without counsel. He's waived his right to be represented by counsel. How will we proceed?
Thank you, Your Honor. I did have an opportunity to speak with Mr. Bowser. We went over the 2 counts that are outlined in the complaint. I extended an offer to Mr. Bowser, Judge, which is as follows. I indicated that to Mr. Bowser that he needs to license the dog in question here and also pay the restitution that's being requested, which I understand is $300 for damage to the fence. That's reference to count 1. If he pays the restitution and license the dog, the people would move to dismiss count 1 and count 2, Judge. It's my understanding, I don't want to put words in his mouth. I'm sure he'll be able to articulate this to the court, but it's my understanding that he is agreeable to that resolution. However, he needs some additional time to license the dog, Judge. So if we could set this out maybe 30 to 45 days, he indicated that should be sufficient time for him to do what he needs to do on his end.
Is that correct, sir? November 26th at 10. November 26th at 10. We'll get you a notice to appear for the date and time. Do you have any questions? Okay, any additional matters, counsel?
Nothing from the people. Thank you.
You're all set for today, Mr. Bowser. Let's see, I didn't see Rebecca Martin for show cause. I did not see Joshua McDowell for show cause. And Shawan Missouri did not appear either. I have a Tia Straiton. Okay. You ready to proceed?
Ask you a quick question.
Yes.
I think I may have missed the 9 a.m. Mr. Riley, maybe.
Ali yet?
Yeah, so I was about to
He
ask
didn't-
about Ali.
He's in custody. I didn't bring him up yet.
Got it. Thank you.
Who's representing Ali yet?
That's me. For
Do you want him brought up?
Yes.
You could bring Ali. I haven't seen Chad Iverson.
No.
Can you bring Deontay up, please?
Yes.
On the record in the matter of the people of the state of Michigan versus Tia Nicole Straiton, it's 14-04243. Council appearance.
Morning, Joel Martinez, appearing on behalf of the people of the state of Michigan.
Jacob Riley on behalf of Ms. Straight.
Straighten, can you hear us? Straighten is non-responsive. Straighten, you need to
Yes, I'm here.
unmute.
I'm sorry. Yes, I was trying. Yes, I can hear, and yes, that's my name.
Okay. Very good. Okay. Okay, today was the date that was set for pre-trial on matters from quite some time ago. How are we proceeding?
Thank you, Your Honor. I've spoken with counsel, discussed with counsel. It's my understanding at this time that what's being offered is for Ms. Straiton to show proof of insurance and also to show proof of a valid license, which are the 2 counts itemized here. No license, no insurance. If she can provide proof of both of those items, Judge, the people will move to dismiss both counts. Thank you.
How much time should I need?
Take a couple of weeks, Your Honor. Just bear with something.
November 19th at 10.
November 19th at 10. Ms. Straiton, do you have any questions for the court? I think she might be frozen.
Yeah, so they want, no, can you hear me?
I can hear you now. It says that you have low bandwidth, so that means your signal is going to be a little low.
Okay, yeah, I was saying I don't have a vehicle at all at the moment. And I'm in the process of trying to get my driver's license. I have to pay Wayne County $30, and then the Secretary of State said I would have to pay like a restitution fee before I would even be able to take the written part of the driver's test because my license has been suspended for over 7 years.
Okay, so it sounds like you're gonna make those efforts and you'll.
Yeah, I've
let
been
your
making progress. It's just
Yeah,
slowly but
continue.
surely.
Yep, no worries. That's what we want you to do, make the project progress, because what the goal is to make you get your license.
Yes.
So we're gonna set it out to the 19th. You provide your attorney with an update as to where you are with that progress. If you've made progress, the court can give you more time. If you don't make progress, that's a different story. Okay?
Okay, but so then I have a question. So as far as me having warrants, are those now gone?
Warrants where?
I had warrants in Lansing. I found out because I was trying to go see my fiance in prison and I was unable to get approved because I had 2 warrants in Lansing for these.
Yeah, it probably was for this, but you were arraigned on it, so the warrant is no longer there. As long as you come to court, you won't have a warrant.
Okay.
Do you have any other questions, ma'am?
No, ma'am.
Okay, we'll see you at your next court date with an update on your license.
Okay. Thank you.
You're welcome.
Have a nice day.
You too.
Yeah. So,
Okay, these are the matters of the people of the state of Michigan versus Ali Diet, 24-02873 and 23-02911. Appearance, please.
good morning, Joel Martinez, appearing on behalf of the people of the state of Michigan.
Jacob Rowley on behalf of Mr. Diet.
Okay, today was the date that was set for pre-trial on one count of domestic violence, and I think there was a violation of probation matter scheduled for today. Okay, how are we proceeding on this?
Thank you, Your Honor. I did consult with counsel. It's my understanding that the domestic violence case judge were requesting a final pre-trial and jury trial date.
That's great.
And as it relates to the probation violation, it's my understanding that he will be tendering a guilty plea judge to those violations.
It's also great.
After trial, November 19th at 8. Jury trial, January 13th.
November 19th, 8 a.m. for final pretrial in person at the court. Jury trial, January 13th at 8 a.m. Do you have any questions about that file? Mr. Giat?
No.
Okay.
I'm here now. You said you were comments around these very important certain questions. No.
Okay, and as to the child abuse matter 23-02911 that he's on probation for, he was arraigned on these. Let me find the violation. It's fine.
I think it's for absconding, judge, if I'm not mistaken.
Okay, let's see. I do have. Well, this is from August 6th. That is. Okay. That was the insurance. July 31st. Okay. I have a violation that you were arraigned on, in fact. And it's from July 31st. The allegations were that you failed to report to probation on July 10th, and that you failed to set up a new testing file in May. Oh, you're the person that they let move to Maine without my permission. Got it. Okay. And so you were scheduled for a probation violation hearing. You appeared virtually, at least your name appeared in my virtual courtroom on the 6th. I noted that. But then you left before starting your Zoom. And so a bench warrant was issued in a remand. Let's see. And he's going to plead guilty on that.
Yes, ma'am.
Is that correct?
No.
Raise your right hand. I don't know. Okay, thank you. Raise it.
I can't.
Okay, do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
No.
Thank you. Okay, you have the right to have a contested hearing on this matter. And you have the right to have your attorney represent you at that hearing if you're found to be in violation of your probation status. Your probation can be terminated. You can be facing a term of jail time, and that could be the full term that was from the underlying incident. You also could have your probation extended or other oversight imposed. Do you understand that?
No.
Okay, you want to waive your contested hearing?
Yeah.
Are you sure? You looked over at him like he wants to waive it. Do you want to waive it?
Yes, no.
Okay. Anybody, are we boring you?
No, ma'am, no, ma'am. You're absolutely not, ma'am.
Oh, okay.
I'm just new legal term. I'm getting accustomed to, that's all.
Okay, any threats being made to you to get you to waive your hearing and plead guilty?
No,
Any promises if you plead guilty?
no,
As to the violations that the court just read, which is that you failed to report to probation back in July of 2024, that you failed to set up new testing while in Maine. How do you plead?
guilty, no.
On a factual basis, please.
Mr. Diaz, is it true that you were sentenced to a term of probation by this court in December of 2023?
Sir.
And as part of that probation, were you required to report to a probation officer at least monthly?
Yes.
Is it true that you failed to report as ordered on July 10th this year?
Yes.
Were you also required to set up regular substance testing wherever you reside, including the state?
Yes.
And is it true that you did not set up testing in Maine?
I did try, but it wasn't successful, but yes.
Okay, the court is satisfied with the factual basis. I'll accept your plea if I get you made freely, voluntarily, and intelligently. I'm not 100% sure why, but there should have been another violation for picking up in the case. But I don't see that in here. I would like actually some understanding as to how did you move back from Maine?
Yes, I didn't move back from Maine now. I just came to visit my children.
Oh, okay. Okay. You can make allocution before the court sentences on the violation. It says here defendant is absconded over the summer when he found out about the violations. Defendant failed to take responsibility for anything during probation, stated that he waited 40 minutes for a probation violation arraignment and left, and was arrested on the 23rd of September for assaulting, threatening behavior. Defendant did not learn anything during probation and continues to be a problem in the community. The recommendation is to terminate the probation status and to impose a full term of jail. You can address the court.
Your Honor, my client admittedly has not been successful on probation. I think trying to do everything remotely from Maine from they came back to the community. Be arrested on warrant. At this point, frankly, I don't dispute the analysis of the probation violation report. I would note that my client has been in custody on this current stretch for 29 days. I believe he had a significant amount of jail credit prior to that on the same file, but I don't know the number. I simply asked the court to take home that hotel.
This is not the first violation that I've had for you since being on a term of probation. You want to add something?
Your Honor, my client just wanted to point out that he did complete a class that he was required to take as part of probation, and he did pay a significant, well, I think the entire balance of his fines and costs that were
Okay. Yeah, I see that he completed a parenting class.
No.
It says that you paid your fines and costs, that you had zero balance. That was noted on the recommendation. However, also noted on the recommendation that your over attitude is poor. I find that consistent with your body language in court. That's why I asked you, were you bored? Because I'm talking to you. Don't disrupt me. I mean, you're leaning over as if you got better things to do. The other impression from your probation officer was that your acceptance of responsibility was poor. And then it said overall progress was only fair. And so it's nice that you paid your fines and costs and that you attended a parenting class, but that didn't make you compliant with your probation terms, which weren't many. And it didn't make you report even when you were given an opportunity to, for whatever reason, leave the state of Michigan. The court was not aware that you were granted that opportunity, and that was addressed after I was asked to give a warrant for you failing to appear and set up testing after moving to Maine. I said, well, what is he doing in Maine? And that's when I found out that you were allowed to go to Maine. I never approved that in the first place. I wouldn't have approved it. And then I granted the warrant with a remand. You appeared, which means you were aware that you had this probation violation. You appeared, but of course, we didn't move on your time frame. You waited 40 minutes and you left without addressing your court responsibility because of your criminal conviction. And then now I have a new file, assaultive in nature, that's pending. So I could care less that you paid fines and costs. That's the least of my concern. I discharge people successfully from probation when they still owe fines and costs. I don't care about you paying fines and costs. What I cared about is that you followed the court orders, you did what you were supposed to do, that you weren't engaging in violations that were just demonstrative of you being careless and not concerned about being on probation. And that's what I have here. You had more than one violation before you completely absconded in, but for the fact that a welfare check was allegedly done on the new file, we would not have you here to address this matter and take responsibility for it. And so I believe and agree with the overall impression that your attitude has been poor and your acceptance of responsibility is poor. I'm going to discharge you from probation. You will serve the full jail term as recommended by probation. You were originally sentenced to 365 days in Ingham County Jail with credit for 22 days. And then whatever credit you just accrued after being picked up on the 24th for the new domestic violence that's been pending, that will be credited as well. You'll serve the remaining balance of the 365 days in the Ingham County Jail with no GPS tether release. Do you have any questions about that?
You said I would serve the whole 360 something days.
The remaining balance. So you served 22 days before I sentenced you to the 365 days. I sentenced you to 365 days Ingham County Jail with credit for 22 days at the time that you were sentenced on the child abuse 4th. And when I did that, I said I would suspend the balance of the 365 upon successful completion of a term of probation. You have demonstrated that you cannot successfully complete probation, so I'm discharging you from any probation status, terminating that status, and you'll serve the jail time that was originally imposed, okay?
Yes, ma'am. And also, Judge, I do apologize if I do look bored, but I'm not bored at all. I'm severe pain. My foot is throbbing right now. So I'm trying my best to try to keep a smile face at the same time.
You don't need to smile. I'm not disputing that you're in pain. You're in a wheelchair, so I would imagine you're probably in some pain. But this is a serious matter, and when I'm asking you questions, the energy that I received from you demonstrated to me that you weren't concerned. I saw more energy when you talked to your attorney.
I apologize, ma'am.
Okay. Your apology is accepted. It's noted. Any additional matters for the record?
Nothing further from the people, Your Honor. Thank you.
No, Your Honor.
You're all set.
There's a couple problems. So 2 years in the return, so they've already decided to and then sent so